Hello, everybody. Thank you for joining us today. My name is Henry Lindpere, and I'm a senior immigration counsel here at Manifest Law. Manifest Law is a modern immigration law firm focused on talent visas and extraordinary ability, as well as temporary work visas for tech companies, entrepreneurs, and today I'm here to talk to you about the H-1B and the potential of using the H-1B for your own startup. And before we jump into the content, just also the mandatory disclaimer here that this is for information purposes only. What I'm talking to you about today is not considered individual legal advice. I'm not your attorney, and we don't have an attorney-client relationship until you engage us and hire us as a law firm to represent you, which I'm hoping that some of you will consider doing. So our topic today is H-1B for founders, pathways, pitfalls, and alternatives. Starting or self-sponsoring a company in the US. I'm going to go through some content first, and then we'll leave time for Q&A later. So you can put your questions into the chat, and then we'll try to go through as many of them as possible before we run out of time. So the main questions we're looking at here today is, can you really start and run a company while on H-1B? And is self-sponsorship through your own business actually possible? Also, what is the real world experience versus what's on paper? What's the difference between the blog posts, what ChatGPT is telling you, what's in the regulations, and what we actually see in the real world when you try to apply for something like this? Some key things to know about how this works. H-1B, as many of you know already, is a specialty occupation visa. What that means, to kind of try to put it in as simple terms as possible, is that it's a visa for a job that is a specialty occupation, or the job that is so difficult to do that it requires somebody having a bachelor's degree in order to be able to do it. The legal terminology there is that it requires a body of theoretical and practical knowledge that's so specialized or so specific that you must have learned that specialty thing at a university, at least at a bachelor's level or higher. For example, electrical engineering or computer science, and then having a job as a software developer, versus somebody working in customer service where a degree is not required, then that doesn't qualify for an H-1B. When it comes to the owner sponsored, or what they call beneficiary owner, that means if you are at least the 50% owner of the company that is trying to sponsor you for an H-1B, then the focus there is it has to be a job that qualifies as a specialty occupation, and at least more than half of the time spent on the job has to then be on the duties of the specialized work. So basically, that means that if you're going to be the CEO of a tech startup, then if you spend more than 50% of your time on CEO duties rather than actually doing the, let's say, the development work, then that's not going to work for USCIS. They're going to push back on that. So the first thing that you have to look at is, what is going to be the job that I'm actually going to be doing in the company, and how do I structure it in a way that it matches one of the technical jobs that requires an H-1B or qualifies for an H-1B. The next thing that you have to show in the petition is that there will be a valid employer-employee relationship. So even if you own the business, you have to have documentation and company structure in place to show that the company is separate from you. The new language in the regulations is there must be a bona fide job offer, and basically that means that the bigger the company already is, the more other parties that are involved in there, the easier you're going to have proving that. So an ideal situation would be having a board of directors that consists of more people than just you, maybe three people when you are one of the board members and there's two other people, and then you can show that your role, hypothetically, you're going to be the CEO or lead engineer, let's say that you have to report to the board of directors, and the board of directors then technically has the ability to hire, fire, and discipline you. So even if you are the majority shareholder of the company, at least in theory, there's a possibility that you could get fired. So that's one of the things that USCIS looks for in separation between you as an individual and the company that you own, that's legally a separate entity, but it also has to be something that's not just your puppet. And then the last one is a viable business structure beyond the founder. And the key there is basically really that it should be more than just a shell, or just a company on paper. The advantage, or the stronger case, is going to be the one where the company already has something that it can show for, in terms of, does it have a product ready, does it have a service that it's offering, are there already contracts in place, is somebody already paying the company, is there revenue, are there clients. It's very hard to start from completely zero and just get your organization set up, get a employer identification number, and then immediately file for the H-1B visa. I think the advantage will be for people who are essentially running the business already, perhaps from abroad, and then they apply for an H-1B visa, or somebody who is in a different status and then they start switch to an H-1B. But going from not having anything in the US and then being physically already here and then switching to an H-1B, that's going to be really the practical challenge, and we'll get to that in more detail in the sort of reality versus paper, right? The main challenge for founder H-1B petitions is going to be the fact that as soon as you own 50% or more of the entity, you have to disclose that in the paperwork, because the forms ask for that information, right? They ask for, do you have an ownership interest in the petitioner? And the moment that you have 50% or more ownership, then it triggers higher level of scrutiny and puts certain guardrails in place, and some additional sort of more stricter requirements for the petition. That means that if you are actually one of multiple co-founders who owns less than 50%, then you might actually have a much easier time, and your H-1B petition might not look all that different from the H-1B that a different employer might have filed for you in the past. But if you have that 50% ownership or more, then USCIS really is going to pay attention to those things, like what is the job, how much of your duties is spent on, or time is spent on which of the duties, to make sure that at least the more than 50%, like we mentioned, is spent on the specialty occupation. So if you're saying I'm going to be the lead engineer in the company, then they want to make sure that it's actually the engineering job that's taking at least 51% of your time, rather than the management and sales and the connections and kind of brand building and other things that you might be also doing as part of your role. Secondly, that relationship, that bona fide job offer and the corporate structure and everything. And then that means that there is a higher risk of RFEs. So if you don't have enough details, then you're gonna experience higher rate of requests for evidence, and USCIS is likely to ask for a lot of these things. For example, they might want to see a business plan really shows, okay, what are you going to do in the next 3 years exactly? What's the plan? What are your projections? Where are you hoping to get the business coming in, what is the expected revenue, all of these things. And then lastly, the visa is specific to an employer and specific to the job that the petition includes. So that means it limits flexibility. Many of you are already familiar with that when you've been in your H-1B job for a bigger company, right? That if there's a material change in the job duties, then the company has to file an amended petition and update USCIS on saying, hey, we changed the job, they're now doing something else. The same thing applies here, that in the real world, if you're running a startup, you might start with idea A, and then 7 months into it, you just realize that, okay, this thing that we were trying is not going to work, but it seems like this other thing that we've been doing is getting more traction, so maybe we pivot to something else, and you might change the focus of what's going to be the service or product that you're offering. But if your job duties change during that pivot, then you'd also need to do an amended petition and let USCIS know that you're now doing a different kind of job. And of course, with every amendment, there's the risk that what if they think now that this new job is no longer eligible for H-1B, or maybe when you initially applied for the first H-1B, you had more cash in the bank, and now that you've pivoted, you need to do an amended petition, but you no longer have a very nice looking bank statement to show USCIS, for example, in terms of the company's financial situation, right? These practical limitations and legal requirements make it a lot harder in practice to get and maintain the H-1B, because the legal requirements are really more focused on ensuring protections of the labor market and to prevent abuse, and they're not really loose enough or flexible enough as like real world entrepreneurs would like them to be, who just need to move fast and focus on the business and not worry that every two steps they take they have to consider what's the compliance or visa risks here. All right. Uh, Here, I just want to clarify some of these concepts of what does that even mean when people Google it or talking about it. I've seen a lot of content out there talking about self-sponsorship, and really, it's not self-sponsorship in the sense that you as a private individual are applying for an H-1B. Rather, it just means that your own company has to be the petitioner, but USCIS has sort of formally acknowledged now in writing that founders who are owners of their own companies could be the beneficiaries of an H-1B visa. I was thinking about this just before we started, that there's a change in the regulation. If you Google H-1B modernization rule, that's the most recent update that became effective in January 2025, that really talks about this beneficiary owner, and how you can be the owner of a company and have that company sponsor you. There's a little bit of a change in the wording in the regulations, but it doesn't really change all that much in terms of what is the regulatory framework there. They already hinted at this years ago that this was technically a possibility. Now they just kind of clarified and said it in the newest regulation that yes, you can be the owner of a company that petitions for you. But like the second bullet point here, there are requirements for the company to act as your petitioner. So the minimum thing that the regulations mention is that there must be a bona fide job offer, and that the petitioner must be a US legitimate US entity that has an employer identification number. But in addition to that, what they're really looking for is also the separation of ownership and control. That's the board of directors that I mentioned earlier, that the board must be the one that's overseeing the work of the founder. The founder has to be basically reporting to somebody, reporting to the company, and the company is overseeing the founder's work, even though in reality, if you are the sole founder and 100% owner of a company, you kind of have full control and you do what you want. But for an H-1B petition, you're going to have to separate that a little bit and put in place some legal structures in the corporate governance documents to give the board of directors some control over what you do. And the key probably there for most people, practically speaking, would be to find board of directors members who to put into your board that you can trust, because if you own 100% of the company and then you put people into the on the board that can technically vote you out or fire you, then you need to make sure that these are people you can trust. And people have asked me, for example, oh, can I just put my wife as one of the directors? And I would say, yeah, that if it's too obvious for USCIS to see that this is a sort of a board of directors in name only, but in reality they are not going to ever take any action that's contrary to your interests as the founder and owner, then it might not work, right? So the safest thing would be either if you have multiple co-founders that you're all on the board, and that's one way you can show that nobody has no one person has complete control, or you pick your cousins and your classmates and your best friends and people that you really trust, or for example in of course opportunities for maybe some angel investors, if you can already get them to commit, then maybe they can join the board, or VC investors if you're already at that stage. And like I alluded to earlier, the practical thing is really the documentation of they want to see more than just a shell company. And what that means is they might ask you for a business plan and with financial projections, and really some ideas of what's your market, what are you doing exactly, who are you trying to sell. And then lastly, going back to that specialty occupation requirement for H-1Bs, that when I do, let's say, an H-1B case for a larger company, if there's a computer science degree and then there's a software developer role, then the explanation to USCIS of how the job matches the degree and the person, that doesn't have to be super detailed, but you're going to have to be much more detailed when it comes to your own company's your own company sponsoring in these situations. I don't know, maybe some of you are familiar with the L1 visa if you've been transferred over from abroad, for example, to the US. I would describe maybe the new H-1B requirement here as similar to the L1, where USCIS usually asks, give us a detailed breakdown of all of your duties and responsibilities, and then also how much time from your work week is spent on each specific duty or responsibility. So it could be that a big company H-1B can be just a bullet pointed list of your duties, but when you are the owner of the company, then you're going to have to broaden that with more detailed descriptions of exactly what are the duties, and then also specifying exactly that, okay, here's how much 20% of my time is going to be coding, 20% is going to be reaching out to potential customers or overseeing other engineers or management duties or admin duties for the company or things like that. And then those percentages of course have to add up to 100, and then more than 50 needs to be specific to the technical or H-1B occupation that you are claiming in the petition, and less than 50 can be only on the management and admin side. And really the practical, or what I would say, like my sort of conclusion on this updated H-1B rule is that for many people, getting an H-1B for their own company is actually very restrictive, and there's going to be these difficult requirements to meet, which is a reason for why it hasn't become super popular yet. So if it was so easy, then you'd probably already see a lot more of these, and we've seen a relatively small amount actually of people who choose this as a good fit. And it's kind of, I would say, because the rules create a sort of catch-22, right? That in order to get a visa for your own startup, you have to show that your own startup is already, a fully functioning company that has some traction, and it's more than just a company on paper. But if you are already inside the United States working for somebody else, then you cannot get your company started and to get to that level without going and working, basically risking working without authorization or getting an allegation from USCIS that you worked without authorization. So I would say the people who I can see or who I can picture benefiting the most from the H-1B for founders are, for example, people who are maybe running their startup from abroad, right? So let's say you quit your job in the US if you're here, and maybe you can get a permanent residency more easily in Canada. So maybe you can go to Canada and start building your startup from there, running it remotely, even though it's a US entity, maybe you can run it remotely from Canada. And then once it has more traction, then you would have enough of the proof that they need so that you can do the H-1B. Or maybe you've already been running your company from abroad anyway, from Europe or from India. And then once you have a little bit of traction, then you put yourself in the H-1B lottery through the startup. And if you get picked, then hey, now that's an option for you. And that's going to be really good for people who don't yet have a lot of experience. So let's say you finished your undergraduate or master's degree in a technical field in Europe or in India, and you've been running your startup now, and you don't really have a robust long track record of experience, or maybe you've just been trying different startups for several years and none of them have really taken off to such a level that you could be considered extraordinary or super amazing at your in your field, then the H-1B might actually be a really good fit for you. For many other people who are in the US and, for example, they already have a startup, maybe they were in a different status, like on an H-4 EAD or something like that, then in many cases, if your startup is already big enough and has traction enough so that you would have all these requirements met that the H-1B requires, then you might also be in a situation where you already have enough that you qualify for an O1. And that's why I see a lot of people coming to us that are initially interested in the H-1B, and then we might still end up actually not doing an H-1B for them, but rather focusing on building up for an O. There's multiple sort of benefits for why that makes sense. One of the things with an O that makes it really attractive is that it's not just tied to one employer. So like I mentioned earlier, an H-1B is job specific and employer specific. It is possible to have multiple H-1Bs, so you could potentially have your full-time H-1B for whoever you're working with for right now. And then if you have a startup that's ready to go, then you could do a concurrent H-1B, even a part-time job for your own startup to work on that as a side hustle while you maintain your full-time job. But the annoying thing about it, of course, is that you need to have two different H-1B filings. The cool thing about an O is that you can have what's called an agent-based O1 petition, where you have one O1 filing and it can be for multiple jobs. So, for example, I recently did a serial entrepreneur O1 for somebody from Europe who had three different job offers in the United States. One was their own startup, and then there were two other startups that they met in accelerator program in Europe that wanted to hire them. So we had three different job offers, and then I did one petition, one filing, and they got an O1 visa, and now they are here. They have a 3-year O1 status, and they're authorized to work for all three, and they don't have to worry about doing multiple filings for each special or each specific job. There's also more flexibility in there, that it's possible to do it for people who have like shorter term engagements, like freelance gigs and things like that. And the focus of an O1 is on extraordinary ability rather than the job being a specialty occupation. So as long as you meet the requirements to show, let's say, that you are an amazing entrepreneur, then you can come on an O and do the job of a CEO. And USCIS isn't going to pay much attention to how many percent exactly of your duties are for management, for coding, for whatever. It's just that you are among the top 10% of people in your specialty, and you're coming here to use those skills to do a job, but it's not detail oriented on the job duties themselves. The other good thing is that there's no annual limit, right? So that means that the focus of the O is on that skill level or achievement level, and that means that as soon as you meet that standard, then you can file. You don't have to play any kind of lottery, and that makes it a really good option for founders with lots of achievements. But like I said, there is that middle ground there of people who aren't quite there at the O level yet, who can benefit from the H-1B rules the way they are now for founders. It's just that there's so many of these other added requirements for the H-1B filing that this can actually stop many people from being able to do that. Because if you're in the US, let's say on an F1 and you just want to switch to running your own startup. How do you get the company up and running and then show that you have money to pay yourself a salary? Because for those of you who are maybe are already familiar with this, but if you're not, then H-1B has very specific wage requirements because they look at the Department of Labor data for what are people in this job making where you're at, right? So if you're in the San Francisco Bay Area and the government tells you that median wage for a developer for this job is, let's say, $100,000 a year, then that means that you have to be able to show with your startup that you're capable of paying yourself that salary. What kind of a person has this much cash laying around just to start their startup, right? So it's very hard to kind of start from scratch and bootstrap the way normally startups begin and still meet those H-1B requirements. So that's why I say it's a good idea that they had, but they still left so many protectionist things in the regulations that it makes it very challenging for many people. Okay, let's see. Oh, yeah, that's the key takeaway, that basically it's structurally complex to do the H-1B for a founder. It is possible, and like I said, the advantage will be for people who've already built the startup remotely and then they come in, rather than the ones who are trying to start it from scratch inside the United States. And because of these various restrictions, we often end up recommending an O instead when we do a thorough analysis. And now let's leave some time for Q&A. So if you want to ask anything about what I just covered, if anything was unclear in what I mentioned, or if you have any kind of scenarios or examples or anything that you'd like to get some clarification on, then go ahead and put your questions in the chat and we'll take a look. How much money is required in the startup's bank account when applying for an O1 visa? There's not really a strict requirement on how much you should have, because with an H-1B, as I mentioned, there are strict requirements for how much you have to pay somebody. There's no strict requirement for how much you have to be getting paid as a founder and owner of a startup. So I've done cases where there's no specific salary, or I've done cases where the salary is very low. You could even say you're paying yourself minimum wage and then you don't have a high salary because the law doesn't mandate for that you have to pay what other people in similar jobs are making. It really depends on kind of where the company is at. So the most critical component for an O is that USCIS does not want to issue O1 approvals for something that they view as speculative. So even if you don't have a ton of cash for the company bank account, as long as you can show that there's already traction, that there's some business activity going on, then usually that's sufficient. For example, if you have a US startup and there's already a contract with some big client that shows that the company is going to be making significant amounts of money per month or something like that, then that already would be sufficient in my opinion. But of course the specific details can change the scenario, because it's different when you are only doing a petition for one job versus if you're doing an agent-based petition and for potentially multiple gigs, things like that. For founders, the strongest or the safest way to go with an O would be to have an agent-based petition where one of the jobs you're going to be doing is for your own startup, but that you also have some side gigs that you can show offers or contracts for, such as invitations to come speak at events, or doing a freelance project, a 6-month contract for somebody else, or something like that. And the specific numbers really aren't so important on the O. It's just about, is there already somebody there waiting to make sure that you know exactly what you're going to do when you get the O. Many people say, "Oh, I just want to get the O visa because I'm amazing," and then like figure out what I'm going to do later. That's the stuff that USCIS does not like, because they say, it's not like a unlimited work authorization where you just get it and then you just start walking around thinking, what's my business going to be like? It's that they want to see already contracts or offers or some kind of business activity. Okay, do you have any more questions? Anybody else? Either about the H-1B or the O, or yeah, it could be something else either as well. Is there a specific time frame for the startup that how long it has to be operational before it can petition for H1 or O? There is no specific time frame, so it's really about showing that it's real, right? So, for example, if you've never run a startup before, and the new entity in the United States is the first time that this name appears anywhere in the world, then you're going to have a higher bar to showing that it's a real enterprise. Whereas if you, let's say, have a company in a different country and it's already got some traction elsewhere, and then you're saying, and now I want to bring that same thing to the United States, then it could be basically freshly formed the moment you apply. So I'll give you one example. That 3-job 01 that I mentioned to you earlier, one of those 3 jobs for this applicant was for a Canadian startup. They had 2 job opportunities in the US for entities that already existed. And they were not very old entities, but they had been running at least for 6 months or more at that time. But the 3rd job offer was actually from a Canadian startup who was hiring somebody from Europe to enter the US and start setting up the US operations and then hiring people and growing the US presence. So the more that you have context and other documents and proof around the startup already being functional, even if it's in a different jurisdiction and in a different market, then the easier it is going to be for you to win on the US side. Because if you're like, hey, we are really good right now in the UK and making tons of money there, and we just want to come and expand to the US, then it's going to be way less of a burden to show that you're going to have some real business here. But if you don't have anything else anywhere in the world, and then you're just creating a brand new startup in the United States, then you're gonna then again, no time limit specifically, but you're gonna have to show some kind of contracts, clients, potential business before they're gonna give you the O, because they don't like speculative applications. Does manifest help with incorporation? We don't specifically do. Some of our attorneys help with that, but most of us were focused on the immigration side, and we are there to give advice on how the organization should be set up, but we don't offer specifically the services of creating an entity or creating those corporate documents. Depending on how many people are involved and how complex is the situation, we might just say, go to LegalZoom or Stripe Atlas or some kind of platform where you can just do that as a quickly as a service on your own. The more complicated the structure is going to be, the more we would recommend that you have an actual corporate or business attorney who helps you kind of think things through. That's especially important if you have multiple co-founders, because then you want to have very clear language in the articles of organization or articles of incorporation, specifying what is the governance structure of the company, what happens if there's a conflict, what happens if you can't agree among the 3 founders what to do, how do you vote on it, is there a way for somebody to be kicked out of the startup. All of these things only need to be answered in the beginning, like in such detail, if there's multiple partners involved, right? But if it's one company that you own entirely, then the setup is going to be a lot simpler, and there's not really a need for an attorney to do extensive work on some of those documents. But depending on the jurisdiction, that's another thing to consider, is that immigration law is federal law, right? So if you come to me, it doesn't matter where you are in the US or in the world, I can advise you on immigration law in the United States. Business law is state specific. For example, I have a license to practice law in Arizona. That means that I can advise on federal law and I can advise on Arizona law. I am not qualified to tell you how some business law is going to impact your company in New York or in North Dakota, right? So depending on where you're setting up the business, you might need a business attorney locally who has a license in the jurisdiction where you're going to be operating. So if you're setting up a Delaware corporation, and you want to have some very robust rules in there for how to manage relationships between the 2 or 3 co-founders, then the best thing would be to find an attorney who actually has a license in Delaware, so they can advise on how the Delaware laws are going to impact the company structure and governance. Okay. Any other questions? Let's see. No, the question is, do we need to give any equity to the board of directors? Board of directors does not have an equity requirement, so you can have an independent board that are just advisors. They can get some kind of compensation for taking on the responsibility, but you are not legally required. At least as far as I know, I don't know a single state where that would be a requirement that a board of director has to have equity. If you look at just publicly traded companies, for example, then generally board of directors have some kind of a pay package or something, but it's not necessary that they have to be the owners of the company. So you could still remain the 100% owner of a business and have a board of directors where none of the other directors have any ownership. Okay. Thank you so much for everybody who is here today, and I hope it was informative. I know it is a very complicated topic, and there are so many of these technical requirements and things that I'm sure it's not easy trying to figure out what you should do or which one you should pick. Okay, last one here. I see somebody posted another one. Says, can someone having entrepreneurial experience set up a fresh LLC and a legit business plan and file for H1 or O1 while in the US before the actual business is operational? Unlikely. Based on what you're describing there, I don't know how that would be viable. Just because, like I said, the the O1 at least, they really don't want speculation. They want to see that there's some action. So if it's just set up and there's nothing else going on, and you don't have any track record from like doing that same thing abroad or something, then that's going to be really difficult. With an H-1B though, I could see it potentially being possible because the law kind of says, okay, there has to be a separate entity and it has to be financially viable, right? So you have to show that you have money to pay yourself a salary, but the regulation itself does not require for the company to yet have any contracts or anything. But I would say then for the H1 option, you'd probably need to have a lot of cash because the H1B company has to have the ability to pay the wage for the H1B employee, right? So let's say you have a job that the Department of Labor says you got to pay at least 65,000 salary for this. Now, if it's an older company, if you can show that my last year's income or my last year's profit was 70K, then you have no problem convincing USCIS that you're going to be able to afford a 65K salary on an employee. If you have a brand new business that there's nothing else there, then you'd need to have a lot of cash on your bank account just to be able to show that, yes, I am able to pay this person this 65K salary per year to start the job. Because if you don't have any contracts or anything, then you have no credible projection for where is this future income going to come from if you don't have it already in cash ready to go. So that's why I said before that really the more certain something is, the more the stronger the case is going to be, right? So that means that whether you have an entity abroad and then you're bringing the same business over here, that makes the case stronger, or whether you've already been running the business remotely from somewhere else, and that's you get more traction. But it's especially hard for the types of businesses where you would need to be here physically to run it and then switch to an H-1B or an O after. Because of that, there's a lot of small business owners or uh, potential entrepreneurs, prospective entrepreneurs who haven't really taken that step because they can't figure out the pieces on the final step there. But I would recommend, if you are serious about it and you want to figure this out, find a way, then consider booking a consultation with Manifest Law. So you can reach out, like it says on the slide here, to help@manifestlaw.com, or you can go to www.manifestlaw.com and you can click on request a consultation on our website. And then our intake team will connect with you. We'll gather some information about kind of what's your background, what's your idea for the business, and we'll try to find the best opportunity for you, whether it's an H, whether it's an O, maybe it's an E2. There's different things that we could consider depending on where you're at in your career, in your business, what are your financials, how much can you commit to the business, all of those things we can look at in more detail. And then, oh, and here we go, manifestlaw.com/webinars is where you can request a consultation. It tells us that you attended a webinar, and we'll be happy to talk to you. All right. Thank you so much for everybody who participated. Thanks for your questions, and I hope it was informative. And I hope to talk to you, some of you, soon. All right. Thanks so much. Have a good day.